Dale is the director of the ACLU's Voting Rights Project, which is all about defending the freedom of all Americans to exercise the most fundamental right in our democracy, the right to vote. And as Bilal said, and as all of you know, this right is under attack here and around the country, perhaps more around the country. We certainly seem to feel like we're in a little bit of a bubble here in Connecticut, that a lot of the horrors that are happening in other states are not happening here, but the reality is that we're very close and that we're in as much danger as we, and by that I mean young men and women of color are in as much danger as they could be in other states. So we're dedicated here to taking on these issues, to trying to make sure that the training and the expectations of police force diversity and the expectation of investigation and prosecution of cases of deadly force are taken very, very seriously here in Connecticut. But Dale supervises the ACLU's voting rights litigation nationwide and has active cases in more than a dozen states. And you can see all of these really important cases listed in your program. And he's testified on various election reforms, not just prison gerrymandering, thank you again, but has been publicly visible on any number of voting rights issues and reforms. And we are proud that since he was assistant counsel at the NAACP, the Legal Defense Fund, he is now the director of the Voting Rights Project for the ACLU. So I want you to join me in welcoming Dale this morning.
Good morning, everyone. Thank you, Sherry, for that kind introduction, and to the other members of the Common Cause staff for inviting me to come up here and for putting this together. I just also want to thank Bilal for the hospitality and the Common Cause board. And also all of you for taking the time out to come here and for this morning's event. It's really an honor and privilege to have the opportunity to spend a few minutes with you all talking about the state of voting rights in this country. So as Sherry said, my name is Dale Ho, and I'm the director of the ACLU's Voting Rights Project. I work out of our national office in New York, where I supervise our litigation on voting rights issues and our legislative advocacy at both the state levels and in Washington to expand voting access. There are basically three principles that guide our work, and they're very, very simple. Everyone ought to be able to vote. Voting should be free and easy. And everyone's vote should count equal. You would think that these principles would be uncontroversial and universally subscribed to. But I'm here, unfortunately, to tell you today that that is not the case. We have seen in the last few years a sustained attack on voting rights unlike anything that the country has experienced in several decades. So I just want to take a few minutes today to talk to you about how we got here, what the challenges are that we are facing, and what we can do about it. So starting with how we got here, I think it's helpful to back up and talk about the history and birth of the Voting Rights Act 50 years ago. In 1965, before the Voting Rights Act was enacted, registration rates for African Americans in the South were dismal because of a variety of tactics that were employed in the states of the former Confederacy, things like literacy tests, poll taxes, and other kinds of devices. African-American registration rates in those states were on average below 25%, and in some states the numbers were even more dismal. In Alabama, about 19% of eligible African-Americans were registered to vote. In Mississippi, it was under 7%. Folks have been working on these issues for decades, but it took the Selma and Montgomery March, when hundreds of people risked their lives, and some people lost their lives, to catalyze a consensus that something had to be done at the federal level to protect voting rights. So after the passage of the Federal Voting Rights Act in 1965, we saw immediate change in the South. Within 5 years, registration rates for African Americans in more than half the states of the former Confederacy were over 50%. So a massive skyrocketing of those registration rates. Literacy tests were abolished. A year later, the Supreme Court abolished poll taxes, and several years after that, we, at the national level, lowered the voting age in all elections to 18. And it really seemed like there was a consensus around this principle of universal suffrage. Debates about voting rights really stopped being about basic questions of access in the 1970s and started being about issues like how are the district lines drawn? Are they drawn fairly? Are they gerrymandered for one party or one community? Are communities of color being treated fairly in the redistricting process? And we didn't really have fights in the 80s and 90s and early 2000s about these basic questions of should everyone be able to register to vote and should people be able to cast ballots. The Voting Rights Act, after the first 5 years of its existence, was used primarily in the area of redistricting and not in the area of basic questions of ballot access. Now, I know most people in the room are probably not lawyers, but for the lawyers in the room, right, if you go on Westlaw and Lexis and you look at the cases that were brought under the Voting Rights Act, starting in the 1980s to the present, over 90% of those cases were in the area of redistricting, right? And starting in the 1980s, the Voting Rights Act was used to try to make sure that communities of color were represented fairly in the redistricting process. And between 1980 and 1992, the number of African Americans in Congress doubled as a result of those efforts. But that's what voting rights advocates like me were really working on 10 years ago. If you asked us 10 years ago, would we be facing these sort of questions and controversies about basic questions of ballot access, I think most people wouldn't have thought that that would be the case. 10 years ago, people were thinking ahead to the 2010 census and what the redistricting cycle would look like after that. Something changed, though, in the last few years. And I locate this change with the results of the 2008 election. The 2008 election saw record levels of participation of young people who participated at rates unseen since the pre-Watergate era. So you had a sort of new level of enthusiasm amongst young voters and also amongst people of color. It was the first presidential election in our nation's history in which people of color constituted over a quarter of the eligible electorate. And if you just compare the number of ballots cast by people of color between the 2004 and 2008 election, huge changes. So Hispanic voters cast 25% more ballots in 2008 as compared to 2004. African American voters, 20% more. Asian American voters, 15% more. And then when you look at Hispanic, non-Hispanic, white voters, the number of ballots cast between 2004 and 2008 hardly increased at all. So we had a major diversification of the electorate in 2008 and almost record level of participation amongst young voters. Right. Suddenly, in the wake of that election, which obviously resulted in the election of the nation's first African-American president, we saw a wave of laws that made it harder to register to vote and cast a ballot. And not just for everyone. These laws seem to be surgically targeted towards the means of participation that were disproportionately used by these emerging segments of the electorate. Between 2011 and 2012, 25 laws were passed in 19 states that made it harder to either register to vote or cast a ballot. And like I said, that is unheard of in recent decades for people who work in the voting rights space. As I said, we were really thinking that the issues in the post-2010 world were going to be around redistricting. We thought there had been a universal consensus that everyone ought to be able to vote, and yet suddenly we see this wave of laws that make voting harder for the first time in decades. I said earlier that these laws seem surgically targeted towards the means of participation used by these growing portions of the electorate. Let me give you 3 examples of cases that the ACLU litigated in the run-up to the 2012 election to illustrate what I mean by that. If you think about the voting process, I think there are 3 parts in the process at which these laws try to choke off participation. The registration process, the voting before election day opportunities, and then voting on election day itself. And let me give you an example from each of those stages of the process. So in 2011, Florida passed a law that did a lot of things to its election system, but one of the things it did was impose new regulations on voter registration drives. What did that mean? It meant that if you lived in Florida and you wanted to touch a voter registration form that was filled out by anyone other than a member of your immediate family, you had to register with the state before doing so. You had to produce monthly reports to the state on the number of voter registration forms that you handed out and the number of completed voter registration forms that you collected. You had 48 hours to submit those forms to the county supervisor of elections office, and if you did not return those forms within 48 hours of them being completed, you'd be fined $50 per form per day. The League of Women Voters immediately canceled all voter registration activity in the state because they did not want to expose their members to liability. The NAACP announced that it would muster only about half as many volunteers as they had 4 years earlier in the 2008 election. They were serious about enforcing this law. I represented the Okaloosa branch of the NAACP, which is in the Panhandle in Florida. They got in trouble with the Secretary of State's office for turning in 2 forms a few hours late. They collected them on a Sunday morning. They returned them on a Tuesday afternoon. Now, why did they return them on Monday that week? Well, that week, Monday happened to be Martin Luther King Day, and the office was closed, but they didn't get 24 hours of tolling from the state. Now, who uses voter registration drives by third parties? Well, if you look at the demographics, about 6% of registered white voters register to vote through a voter registration drive. The numbers for African Americans and Hispanics are about 3 times that percentage, about 18% of those 2 voters. So it doesn't seem coincidental that the state would be targeting those voter registration drives. We and other groups litigated against that, and fortunately were able to get it blocked. Unfortunately, those restrictions were in effect for almost a year, during which a lot of opportunities to register voters were lost. Second example, the early voting process. So again, this example comes from Florida. Florida is one of those states, unfortunately unlike Connecticut, that allows people to cast a ballot early in person. You can go to any number of locations in each county and vote 12 to 14 days in advance of the election in Florida, as if you were voting at a polling place. Florida adopted early in-person voting after the debacle of the 2000 election in that state, and the primary purpose, I think, was to alleviate congestion on election day that makes it hard for people to vote. Right? Now, here's the thing about early voting. Before the 2008 election, if you looked at the demographics of early voters, they were on average older than the median election day voter, wealthier than the median election day voter, and more likely to be white than the median election day voter. 2008 in Florida changed the script entirely. So in the 2008 election in Florida, more than half of the African Americans who cast ballots in the 2008 election did so during the early voting period, right? That is a complete change in terms of the demographics of early voting usage. That's compared to about a quarter of the white electorate in Florida. What's interesting is that continued into the 2010 election. African Americans continued to vote early at higher rates than white voters in Florida in 2010. So it wasn't just the fact that Obama was on the ticket in 2008. There seemed to be some sort of change in the demographics of who uses early voting in 2010. So 2011 rolls around and Florida says, you know what, let's cut back a little bit on early voting. So Florida eliminates the first 5 days of early voting, and they ban early voting on the Sunday before election day. Now, I think there are probably a lot of people in this room who understand the importance of Sundays. For those of you who don't, there's an expression, souls to the polls, right? Where African American churches bring their congregations to the polls after service. It's a way of helping people who don't have transportation access, maybe people who who are elderly or people who are disabled get to the polls and cast a ballot. So African Americans were about 20% of the electorate in Florida in 2008, but they were 30% of people who voted on Sunday. Florida tried to get rid of that. Fortunately, the Voting Rights Act prevented Florida from eliminating those early voting hours in 5 counties. There were 5 counties in Florida subject to the special provisions of the Voting Rights Act, which I'll talk about in more detail in a second. And through litigation, we were able to ensure that the same number of total early voting hours existed in 2012 in those 5 counties as compared to 2008. So thankfully, we had Section 5 of the Voting Rights Act back then. Third example, voting on election day. And I'll take this example from the Lone Star State, Texas. Texas is one of those states that has a strict voter identification law. Now what does that mean? It means that if you want to cast a ballot in Texas, you have to produce one of a limited set of forms of government-issued photo ID. So for instance, a driver's license, right? Yes, if you have that, that's good for voting. A concealed weapons permit in Texas, if you have that, that is good for voting. A University of Texas student identification card issued by the state of Texas, not good for voting. You cannot use that card to vote in the state of Texas, which is kind of strange, right? Because if the purpose of the law is for the state to ensure it knows who you are before you cast a ballot, one would think that any state-issued photo ID card would suffice for that purpose. Instead, if the purpose of the law is to try to change the shape of the electorate, then the law starts to make a whole lot more sense. Well, what's the big deal? People ask me all the time. I mean, most people have a form of government-issued photo ID, and that's true. Most people do. In our surveys that we've conducted, in most states, it looks like about 90% of voters have one of these forms of government-issued photo ID. And for those voters, it's not, in fact, a problem. But for the 10% of voters who don't have these IDs, it can be a very, very significant problem. IDs are nominally offered for free in states like Texas, but of course, in order to get ID, you need other forms of ID or paperwork, which is not free. So in Texas, to get an ID, a free ID, you need a birth certificate. And a birth certificate costs $22. Now, the Supreme Court has held that a poll tax of $1.50 is unconstitutional. And yet, here we are forcing people to pay for paperwork in order to exercise the most fundamental right in our democracy. Now, why is that a big deal in a state like Texas, other than just the government fees? Well, have you heard the expression, everything's bigger in Texas? It's true, right? Texas is a big, big state. And a third of the counties in Texas don't have their equivalent of a DMV, a Department of Public Safety. So you have to drive over to the next county if you live in one of those counties in order to get one of these IDs. Well, everything's bigger in Texas, and if you live in rural parts of Texas, for some people, this can mean a round trip of over 200 miles just to get an ID. And remember, we are talking about people who, by definition, can't legally drive because they don't have a driver's license, right? So what did this mean, right? Obviously, it had an impact on young voters and student voters, but it also has a huge impact on people living in poverty, right? Who can't afford birth certificates or can't muster the travel. And the poverty rate for African Americans and Hispanics in Texas is about 3 times the poverty rate for whites. So we know, again, who this is going to disproportionately affect. Fortunately, again, Section 5, the most potent provision of the Federal Voting Rights Act, was invoked to lock that idea before it went into effect in 2012. So the story of the 2012 election was, I think, so far so good, right? States are trying to restrict the right to vote, but we have strong federal protections that are blocking those efforts. Unfortunately, in 2013, in a decision that you've probably heard of, Shelby County versus Holder, the Supreme Court held that Section 5 of the Voting Rights Act, which required these states that had a history of discriminating against people in the voting context to obtain federal approval before changing their voting laws. The Supreme Court held that this provision, which has been known as the heart of the Voting Rights Act, was not only no longer necessary given changing times, but was in fact unconstitutional, despite the fact that it had been upheld 4 times over 4 decades in previous decisions by the Supreme Court. Justice Ginsburg had a line in her dissent that throwing away this part of the Voting Rights Act is kind of like throwing away an umbrella during a thunderstorm just because you're not getting wet. And the next 2 years, I think, proved her prescient. We saw another wave of laws in late 2013 and into 2014 that made it harder to vote, and the results were very, very different. And I'll just run through 3 examples very, very quickly, just so you get a sense for the challenges that we're facing now today. So in early 2014, Ohio engaged in similar early voting cutbacks, like Florida had a few years earlier. Ohio eliminated early voting days on which over 120,000 people cast their ballots in the 2012 election. We were able to determine through our research that African American voters in Ohio were about twice as likely to vote early than white voters. We brought a challenge to these early voting cutbacks in federal court. We didn't have Section 5 of the Voting Rights Act anymore, but we tried some new legal theories. We got an injunction from the district court blocking those early voting cutbacks. The state immediately appealed to the Court of Appeals for the Sixth Circuit. We got a 3-0 unanimous decision affirming the district court's ordering those early voting cutbacks blocked. And then 18 hours before early voting was set to start in Ohio, the Supreme Court, by a 5-4 decision, stayed that ruling and ordered early voting closed in Ohio for that week. Second example, North Carolina. North Carolina passed a bunch of voting restrictions in 2013 after Shelby County. One of the things that North Carolina did was it eliminated election day registration, which you do have here in Connecticut, which is a great thing because the states that have election day registration, where you can register to vote and cast a ballot in one shot, those states have turnout on average 10 percentage points higher than the states that don't have that. And, you know, kudos here to the election administrators of Connecticut and for groups like Common Cause who were instrumental in bringing that about. North Carolina had election day registration for a number of years, and in 2008 and 2012, over 90,000 people were able to vote as a result of election day registration. 2013 comes around, North Carolina decides to ban it. Again, we brought litigation in federal court under some new legal theories. We didn't win in the district court, but we got a good ruling from the Fourth Circuit Court of Appeals ordering North Carolina to reinstate election day registration for the 2014 election. And again, before the election started, the Supreme Court at the 11th hour issued a stay and permitted the elimination of election day registration to go into effect. Third example, another voter identification law. This one from Wisconsin. We challenged Wisconsin's voter identification law, which, like Texas's, was quite strict. Like Texas's, it had some strange, arbitrary things about it. For instance, an active duty military ID card, acceptable in Wisconsin. A veteran's ID card, not acceptable in Wisconsin. A 4-year student ID card, as long as it met certain requirements, acceptable in Wisconsin. 2-year tech college ID card, which satisfied the same requirements, not acceptable in Wisconsin. Very strange, these arbitrary distinctions in Wisconsin. We went to trial over this in 2013. The evidence showed, and the trial court found, that 300,000 registered voters in Wisconsin don't have one of these forms of identification, and that the rate for African Americans and Hispanics was about twice the rate of white voters for ID non-possession. We won in the trial court in April of 2014. And then unfortunately, the Seventh Circuit reversed that decision, so we lost on appeal. The court allowed Wisconsin to implement its voter identification law immediately. We asked the court to reconsider that decision because it came out after it issued its opinion that 12,000 absentee ballots had already been mailed to people in Wisconsin without instructions informing them that they had to include their ID with their ballot. The state was taking the position that now that the ID law was in effect, that hundreds of voters who had already cast their ballot, their votes just wouldn't count in this election, even though all they had done was follow the rules that existed at the time that they received their ballots. We brought this to the attention of the full Court of Appeals, which consists at that time of 10 judges, and they deadlocked 5-5, leaving the existing ruling in place. We went back to the Supreme Court on this, and this one actually does have a happy ending. The Supreme Court ruled 6-3 that Wisconsin's ID law should not be in effect for 2014. We're continuing to litigate that law today. So what's my takeaway from all of this? The war on the right to vote, unfortunately, that started in 2011 continues today. We have lost our most potent shield in defending voting rights, which was Section 5 of the Voting Rights Act, thanks to the Supreme Court. And the other strategies that we are using to try to defend voting rights in court so far have met with mixed success at best. So we have a lot of challenges ahead of us in terms of defending voting rights. Now, there are things that we can do and that we are trying to do in addition to defending voting rights in court. It's important, I think, to try to go on offense and expand voting rights where we can. There's legislation being proposed at the federal level that would restore some portions of Section 5 of the Voting Rights Act. There's also a bill called the Democracy Restoration Act, which would seek to restore voting rights to people who have lost those rights due to a criminal conviction upon their release from incarceration. And now, given the current state of things in Congress, we're not optimistic about these things passing in the short term, but I think it's important to try to lay the groundwork for these things to pass in the long term. Now, here in Connecticut, I think there are things that we can do as well. Now, obviously, Connecticut has been on the vanguard, I think, in terms of expanding voting rights with Election Day registration, thanks to the work of a lot of people in this room, online registration, which are really, really good things. But there are other things I think that can be done here in Connecticut, right? Early voting, which a majority of states have opportunities to vote early in person. Don't have it yet here in Connecticut. I understand there's a constitutional bar to that, and I know a lot of people here have worked on trying to get that changed, and I really hope that there can be some success with that in the future. Online registration is a great thing, and we're really excited about that. It's kind of remarkable that in 2015, in more than half of the states, you still can't register to vote online, even though you can, order an Uber, right, while you're just kind of standing around. It seems kind of ridiculous, 15 years into the 21st century, that we can't do that. The one thing I will say is that we've done a survey of about 20% of the states that have online registration, and the vast majority of them did not have procedures in place to make sure that those online registration systems were available and accessible for people with disabilities. So I think it's important to try to make sure that any online system is accessible in that way, and we're happy to work with people to try to make sure that that's the case. We haven't looked specifically at Connecticut's online system, but that's something that we would be eager to assist with if we can. The third thing that I'd say also that we could work for in Connecticut is to try to restore the right to vote to people once they're released from incarceration. Right?
We have it.
Oh, the parolee reform has happened already.
Since
If you're still on parole, you can't.
Right. See, so that's right. So probationers have the right to vote in Connecticut, but parolees. That was my understanding.
Oh,
yes, you're right.
That's
So, I think the nationwide standard that we've been trying to push for at the ACLU is that if a person has been released from physical custody, if we think that that person should return to civil society, can work among us, can live among us as a neighbor, then there's no reason not to fully reintegrate that person into civic society as a whole. And we've seen statistics that show that former offenders who vote are less likely to recidivate, right? So I think it's very important, not just for our democracy, but for other reasons, to try to encourage civic participation in the rehabilitation process. It's remarkable. There are states like Utah, Indiana, Montana, North Dakota that actually have more lenient rules with respect to restoration of voting rights for former offenders than a state like Connecticut. So maybe that's something that can be worked on in this state. So I hope that, that my message to you today is not overly gloomy. There's obviously a lot of challenges ahead of us, but there are a lot of things that I think we can do to defend voting rights, not just in Connecticut, but beyond. Thank you very much.
And I think education is a key as far as to make it, I'd like to see it mandatory that this program be put forth and throughout all public schools to educate kids. I'm finding a lot of kids between 15 and then adults 20 to 30 years old, they don't even have any idea how voting affects them in the future as adults. They know more about Jay-Z than they do about their future for voting rights. And I'm finding that a lot when I go around talking with a lot of kids. So I'd like to see that happen, that it become mandatory, that those kind of educational tools, talking about how the voting rights became, as you cited, I'd like to see that mandatory educational tool. What do you think about that?
I think, anything that encourages participation is a good thing. But the challenge is I think that since 2008, the consensus around that idea, that more participation is a good thing for our democracy and for everyone, has broken down. There are some folks, I think most people in this room probably share the view that democracy is best served when more people participate, that strengthens the legitimacy of our government, right? That in a democracy, the legitimacy of the government derives from the will of the majority. It doesn't seem, unfortunately, that everyone shares that view right now. There are some people who only want the people that they think are the best voters to participate, not all voters, right? So their view is, if you don't understand the system, well, maybe that's your problem, and maybe your voice shouldn't count. If you can't muster $22 for a birth certificate, and you can't take the time to register 20 days, 30 days in advance of an election, maybe your vote shouldn't count either. The bill that we're litigating against in North Carolina, I mentioned that it eliminates same-day registration, but it actually did a whole lot more than that. It also includes the voter identification law. It includes a week of early voting that they cut back, and they go after young people. They eliminate pre-registration for 16 and 17-year-olds. Most people, their first interaction with the DMV is the first time they get a driver's license, and that's where most people register to vote. So people often do that at 16 or 17. They don't want to go back to the DMV when they're 18 and they become eligible. So North Carolina used to let these young people fill out a voter registration form at the same time they got their driver's license and then go away, and then they automatically become registered when they're 18. They did away with that. And speaking to your point about voter education, they used to have a high school civics program in North Carolina that encouraged young people to participate. The same bill that I'm referring to eliminated that program. So look at 2008. You had the highest percentage of people 18 to 24 voting since 1972, right? And look at what that resulted in. And one side has decided that their key to winning elections is not to try to convince those young people to vote for them or the new participation levels, groups that are participating in record numbers, but to try to prevent them.
I'm Doug Sutherland. I'm from Democracy for America in Fairfield County, and I also happen to be from North Carolina, so your comments are particularly troubling. We used to be the progressive Carolina, but not so much anymore. I'm just wondering, do we understand where these new laws are coming from? What group? Is this ALEC, or is it the caucus of a particular party?
It's hard to say. I'm not behind any line, so to speak, in figuring out where all that is coming from. There was a time when ALEC had a model voter identification bill, which they were peddling around the country. A number of groups and even members of ALEC started complaining about that, and they no longer have that. I think that was a really, really effective grassroots effort to put pressure on them not to be pushing that bill anymore. They're not now. But it seems like the same kinds of laws are popping up in more states. It's not just limited to, one region of the country, but you see one thing pop up in one place and then it kind of, spreads like pollen on the wind. So, it seems like a coordinated effort.
But right now, there's no way to connect the dots to who's behind it.
I just haven't been spending my time investigating.
Okay. Trying to put out the fires as they come, right?
Yeah, firefighting more than investigating. Dan?
Dale, are there any cases, either pending this term at the U.S. Supreme Court or going to be heard next term that you're watching, or any case at our regional Court of Appeals that would be of interest to us here in Connecticut?
Sure. I think that North Carolina case that I referred to, it's going to trial this summer, so we're a ways away from the Supreme Court, but I think most people expect there be some appellate and maybe Supreme Court action on that case before the 2016 election. The Texas voter ID case has been heard on appeal. There's no decision yet from the appellate court there, but everyone I think expects or thinks it likely that the Supreme Court will weigh in on that case before the 2016 election. There is a case concerning a proof of citizenship law that Kansas and Arizona have that the Supreme Court on June 25th will decide whether or not it will take. Now, this is a law that Kansas and Arizona have, and also Georgia and Alabama, so it's an example of these kinds of laws starting in one place and then they pop up in other regions of the country. It requires anyone who registers to vote to submit documentary proof of citizenship at the time that you're registering, right? Now, in most states, you simply sign an attestation under penalty of perjury, which subjects you to a federal criminal penalty of several years in prison and a $10,000 fine if you are in fact a citizen, and there are ways to verify that people are citizens after they submit their voter registration forms. But Kansas and Arizona want to mandate that everyone has to submit like a copy of a birth certificate or a passport when you register to vote. Now, again, this is one of those things that doesn't sound like a big deal to most people, right? What's the problem with that, right? Well, think about voter registration drives, right? If you're on the street, if you're at a county fair or in a grocery store, and you're trying to register people to vote, people generally are not carrying around photocopies of their passports or their birth certificates with them. And even if they were, they're highly unlikely to hand that over to a stranger, right? So what it does is it kills voter registration drives. It makes them virtually impossible. And in Kansas, over 20,000 people have tried to register to vote and had their registrations held up because they didn't submit documentary proof of citizenship. So it's actually kind of a big deal. And I think we're watching to see if the Supreme Court takes the case.
Do you feel like mandatory voting, like they have in Australia, would ever pass constitutional muster here in the United States?
So I haven't thought about that question specifically. A lot of people are asking now about automatic voter registration, which Oregon has, and I think what's critical about that is there's an opt-out system for that. So Oregon doesn't force everyone to be registered to vote. If you want to opt out of it, you can. I think it would be very difficult to defend the constitutionality of a system that required people to cast a ballot. This is just me giving you my gut reaction here. I haven't done a careful legal analysis of this question, but it seems like the right to vote may also entail the right not to vote and not to participate in an election. So I think it would be hard to have mandatory voting here in the United States.
Even with none of the above option or something like that?
I think that would be a little bit different. I'd have to think about it a little bit more. I think it would be kind of challenging. We believe that with the ACLU, right, we strongly believe in freedom of expression, and that also, I think, entails the freedom not to express oneself.
But I wondered what kind of arguments is the other side using to justify these actions, and what can we as advocates do to battle against those arguments?
So the argument is that if you don't request photo ID from people in person, there will be voter fraud, right? And we've litigated these issues in many states, and time and again, these states cannot identify any examples of people who actually go up to the polls, pretend that there's someone they're not, and cast a ballot. And if you think about it, it doesn't make a whole lot of sense to try to do that, right? If you want to try to steal an election, you probably need some sort of inside help. You probably would use absentee ballots or something like that. Going to a polling place and pretending to be someone else is an awfully inefficient way to go about corrupting the process when you're talking about elections that are decided by oftentimes hundreds of thousands of votes, right? You have to know where someone's polling place is, you have to know that they haven't voted yet, you have to know their address and hope that no one recognizes you. It's and then only change one vote, right? It just doesn't make a lot of sense. I think Texas was able to find 2 examples of this happening in its history. Wisconsin couldn't identify a single one. Now, that being said, it is a very big challenge for us as advocates on this issue, because most people believe that this kind of fraud happens, right? Or that it's even rampant. So I think we have to continually emphasize that, of course, we are in favor of election integrity, because the other side tries to make it sound like we're in favor of people cheating, right? Of course we're in favor of election integrity. And of course we're in favor of vigorously enforcing laws that protect the integrity of our elections. But we also have to make sure that whatever requirements that we put up, right, that there are mechanisms by which people who who can't satisfy those requirements can still find a way to verify their identity and pass the ballot. The best that I can say.
Thank you.
All right, well, thank you all very much.